कैसे होता है, क्या क्या चाहिए, कैसे रिक्वायरमेंट मीट करना है. तो वी विल स्टार्ट विद द सेकंड एस्पेक्ट, दैट इज द प्रोसीजरल पार्ट ऑफ पेटेंट्स. या नेक्स्ट. सो ब्रश अप करने के लिए फिर हम जाएंगे. पेटेंट इज अ इन्वेंशन, property right granted by government for a period of 20 years. Basic requirement is novelty, inventive step, industrial applicability, section 3 and section 4 exceptions, right? इसके बाद में हम एक्चुअल प्रोसीजर में जाएंगे. नेक्स्ट. अच्छा, अभी पेटेंट कौन फाइल कर सकता है? हु कैन फाइल अ पेटेंट एप्लीकेशन? So for application for a patent for an invention may be filed by the following person: true and first inventor. Whoever is the first person, whoever has invented that thing is the true and first inventor. Then true and first inventors assignee. What is that assignee? That we will see. Assignee is a person who is working under some collaboration or some work. For example, you are working under Shivdare College, right? You are using Shivdare College lab. So whenever you are using some other research organization or any other working platform, so you have to sign an assignment. What is that assignment? That assignment is you have to give a declaration that whatever intellectual property resulting during the tenure of this work or during the tenure in the college will be the property of Shivdare College, right? So you will be giving an assignment. So that is the assignee. Suppose you are working in a company, pharma company, or you are working in a university, or you are working in a research organization. Certainly a clause is there while getting an appointment. तुम्ही ज्यावेळेस कुठेतरी ऑर्गनायझेशन जॉईन करता तिथे एक अपॉइंटमेंट करते वेळी एक कॉन्ट्रॅक्ट यू हॅव टू साइन. That is, you whenever you get an appointment letter, that is subject to some terms and conditions. One term of condition is that जी काही इंटेलेक्चुअल प्रॉपर्टी तुमच्या वर्क त्या पिरियड मध्ये काम करणार त्या पिरियड मध्ये विल बी द प्रॉपर्टी ऑफ दॅट ऑर्गनायझेशन. म्हणजे त्या कंपनीची ती प्रॉपर्टी होईल. देअरफॉर यू हॅव टू फाइंड असाइनमेंट. नेक्स्ट. सो असाइनी कॅन बी, नाही मॅडम याच्या आधी okay. Then legal representative of the disease and true and first inventor of his or his assignee. Legal representative, for example, somebody is doing research, somebody has filed a patent application, and by chance or by accident, by some mishap, the person dies. Then the right will be given to the legal representative, whoever, maybe his son, his wife, his daughter, or any person, maybe his parents. So that is the legal assignee. So these are the persons who can file an application. कोणीही पेटेंट application file करू शकतं, provided he is a citizen of India and he is a person of sound mind. So any person can be with single or two person jointly, or a college or a university or a research organization or any industry can file a application. Then where to file, right? Now we have 4 patent offices and we have certain jurisdictions. Now we have a patent office in Mumbai. The territorial, where the territorial jurisdiction lies is states of Maharashtra, Gujarat, Chhattisgarh, Madhya Pradesh, Goa, Daman and Diu, along with Dadar and Nagar Haveli. So whenever a person who is having address in this area, in the states, has to necessarily file an application in Patent Office, Mumbai. So you are in Solapur. Okay. 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 Oh. हा येस त्याच्यावर हा याच्यावर हा. So is it okay? Speaker. हॅलो एक कुठला तरी बंद सेटिंग्स वॉल्यूम हा इथं म्यूट करा हा.
हॅलो
ओके ओके होतंय आता हो हॅलो no it's okay okay हा yeah so coming to the part of filing, so I told you the territorial jurisdiction of Mumbai office is states of Maharashtra, Gujarat, Chhattisgarh, Madhya Pradesh, Goa, Diu, Daman, Nagar Haveli. So whenever a person wants to file an application or is having an address in this location, in this jurisdiction, he has to necessarily file an application in jurisdiction of Mumbai, patent office Mumbai. Then in Chennai, the states of Andhra Pradesh, whenever these people want to file an application, they have to file it in Chennai jurisdiction. Then Delhi, states of Haryana, Himachal Pradesh, Jammu Kashmir, Punjab, Rajasthan, Uttar Pradesh, Uttaranchal, Chandigarh, and Delhi. And for rest of the part is Calcutta. So we have a territorial jurisdiction under which this application has to be filed. So first we told anybody, any person can file irrespective of his education or irrespective of anything, provided he should be a citizen of India and he should be of sound mind, right? Then the addresses are there. These are easily available on our website also. So I will not go in detail with this. Now coming to application. Then before filing an application, we need to understand what sort of application we have to make, right? So there are almost 6 to 7 categories of applications, types of applications that can be made to patent office. Now we will discuss in detail. First of all, an ordinary application under Section 9 and Section 10 of the Act. Now, what is that ordinary application? In the before one session, two persons said that they were having the same idea. Right? Two persons were having the same idea, right? Yeah, I also have the idea. I also have the same idea. We are thinking in terms of that idea. Now, the question comes: who will get the right? Both are thinking in the same way. But I told you earlier also, if the person who comes first, whoever approaches patent office first, asks the priority first, will get the patent order. So there are very important criteria under ordinary application. Ordinary application is nothing but an application when an idea strikes to your mind. You want to make process for making a hemoglobin or process for making any other protein. Now, when that idea strikes to your mind, now you are in chemistry second part, I suppose. So you might be having some research project, and you might be having some thinking that I will do project on that part. So before going into that, you have a rough idea. I am going to prepare a protein. I am going to find out a particular DNA sequence of a particular thing. I am going to isolate I am going to modify genetically modified microorganism. So when you want to do all these things, you need to put this thing on paper. A rough idea. Rough idea. I want to make a so and so, and I will proceed in this manner and file the ordinary application. So ordinary application is of two types. In the form of provisional specification, and the second part is complete specification. Now, what is provisional specification? I told you an idea comes to your mind, you immediately write it on paper, go to patent office, file application, and log the product. That is the provisional specification. Provisional specifications. What is the advantage? And another part is complete specification. When your invention is complete, totally complete, you can directly file a complete specification. But what are the advantages of filing the provisional specification? The idea is in your mind. The process is in your mind. You are going to do or you are going to work out in that manner. So you get 12 months. 12 months time from the date of filing of your provisional specification to file a complete specification. In these 12 months, what you can do? You can necessarily work out with the invention. You can ascertain whether you can get some financial partner. If you are having any financial problems, you can find out potential for the product, in which country you can get the market for that product, or whether it is feasible or not. And secondly, you are locking the priority, so you can take the help of another person also, maybe your guide or maybe your colleague who is also interested in working. So you get 12 months to file that application. So that application is treated as application with provisional application, and then the application with complete specification. So when you file the when your invention is complete, everything is crystal clear, you have arrived at the product, and now you want to get the patent on that, then you can directly file a complete specification. These are the applications which are originating in India itself. So you can file these applications in India, right? So once you file the provisional application, you get 12 months to file the complete specification. Whereas application with complete specification is the application which is complete in all form. It's ready to mature. Then somebody asked me, what is the territorial jurisdiction? What will happen for my application in US or for other countries? Now we have the two routes of filing international application. First of all, you can file an application through convention application, and second is you can file a PCT international application. Now, what is the convention application? Convention application is basically we have signed a convention that is known as Paris Convention, right? So under Paris Conventions, there are convention countries under which you get the equal treatment. What equal treatment? In that countries, you will get the and then another route is you can file an application through PCT. PCT is Patent Cooperation Treaty. So we have signed a treaty under WIPO, that is World Intellectual Property Organization, wherein there is a treaty called Patent Cooperation Treaty, where are 158 member countries. So earlier there were some problems. There were many problems, including fees. So if I wanted to file an application in China, or if I wanted to file an application in Europe, to do a lot of exercises. Different, different laws, different process filing features, then different fees. Then main barrier was, apart from that, you needed a attorney, a patent attorney over that, because you were not aware of the languages that is being practiced in that country. Suppose if you are making an application in China, you are not aware of the Chinese language. So Japanese language you were not aware, the law you are not aware of. So all the inventors had basically many problems for filing, and apart from this, there was huge cost that was required to file an application in that country. So to avoid that thing, to form a common platform, so we have WIPO has signed a treaty called Patent Cooperation Treaty, under which India is also a member of that country. So a single application in English language, or in the local language also, in Hindi also, you can file that application in PCT, wherein WIPO you get a just pick the countries in which you find your product has potential or your patent has potential. So okay, you can select specific countries, or you can select the countries in which you want to prosecute. Then you can come down in national phase application. National phase application is, once you choose, not of 158 countries, but if you want to choose only 5 countries where you think your product or your patent has potential and you will have market. So you think, and then you can just go in the national phase with that country by entering in before 31 months. Then we have patent of addition application. Now somebody asked me during lunch session, or somebody asked me, we have prepared a patent, we have made an application for patent, or we have granted a patent. Now, if you want to modify, or if you want to make some changes, or you want to add something to it so that it has some inventive merit, so you can file a patent of addition over that application. But the condition is that the priority date of that application will be that of the parent application. So you will get the right from that period, from that date, not from the date of filing your patent of addition application. Then divisional application. Again, one thumb rule is, for Section 7 of Indian Patent Act says that for a invention, for a patent, there should be a single invention. But if it so happens that in your complete specification there are more than one inventions, there are 2 or 3 inventions. So under Section 16, the applicant has suo motu right to file a divisional application, or if the controller raises the objection that, if I raise the objection that there is a plurality of multiple inventions in your application, you need to file a divisional application on so and so claims. So you can file a divisional application on that only. Your priority will not be disturbed. Your priority will be the date on which you have filed the application. Then another part is, that's the startup application, that is expedited applications. Nowadays we are granting patent in almost before 1 year. Earlier there was a huge cry and all the things that patents are being delayed. It takes 4 years. But you can file, mainly research organizations, small startups, that is in Makeup India, or in that phase, we can file applications and we can get it as an expedited application granted within 1 year also, provided you cooperate with the system. So I told you, ordinary application is with provisional application. Now what is that provisional? A provisional is a temporary application which is filed when the invention is not finalized and is still under experimentation. So it is under experimentation. That means you have the idea and you want to proceed with that invention, so you can file. Now what are the advantages? The applicant gets 12 months time to fully develop the invention and ascertain its market potential. You can see whether you can have market in different countries or whether there is feasibility in proceeding with the application or not. Then helps in establishing you get the priority. So you enables the applicant to use term patent pending on their product. Now you see many products which are in market. There is written that is patent pending. So that means that application is under prosecution and it will be granted or it will be refused in that period of time. But that is, you can apply that thing also. It's less expensive because it's not a complete application. So your fees is very less here. Then enables to file international application and claim priority within 12 months. So I told you there are two ways. Either you can go by convention route or you can go by PCT route. So you have the potential that if you want, you think that you can get a market in your, suppose your product in China or US or Japan or any European countries, then you can file, select that country and get the application. You can file convert that ordinary application into a international application. Then avoid incurring further expenses if there is no commercial possibility. If you see that there is no commercial benefit, or if it is, there is already this kind of things, or already so many things are available and there is no market potential, and you think that it's absolute waste of time, money and everything, so you need not go with that application further also. So these are the advantages of filing a provisional specification. And in order for the patent to be granted, a provisional complete application must be followed by a complete specification within a period of 12 months. If the complete specification is not filed within the period of 12 months, the applications will be deemed to have been abandoned. That means patent office will think if you are not filing any complete application, complete specification within 12 months, patent office will treat that it is they are not interested and the application will be treated as abandoned. So what are the requirements that you need to put in a provisional specification? So it necessarily comprises of the title of the invention, then idea of the invention, the description of essential features of the invention, and the method of manner of performing the invention. And no need to include the claim. Now what are the claims? Claims are the boundaries for which protection is sought. The boundaries, I want to claim so and so. The claim is for process of making paracetamol. The process for making a paracetamol. So that is your claim. So that is the boundary. So if somebody enters in that jurisdiction, you will have every right to oppose that thing. So here in this case, in provisional specification, it's a rough draft. You have to just mention the title, idea, and how you are going to proceed with the application and the manner, how you are going to make that invention. And there is no need of claims. So ordinary or complete specification can be filed without claiming any priority application. Means you cannot file any priority application in that country. So ordinary application must be complete, accompanied with a complete specification and claims. If the provisional is followed by a complete. So if you are making a complete application, if you are converting that ordinary application to complete application, you should necessarily file the claims. And it should be fairly based on the matter disclosed in the provisional specification and to be filed within 12 months. It should contain claims. Now, once you write your provisional specification, submit it, you work on your invention, and when you finalize your complete draft, or when your invention is ready, then you come with a complete specification. There you necessarily need to add claims for which you want the protection. And the claims are the major part of the invention or major part of the patent application for which you get a protection. Then convention application. So I told you there are convention and Paris Convention, under which if a application is filed, it's an application which is originating in, not in India, but it is originated in any of the convention countries. Suppose a person files application in US and he wants to claim a priority, or he wants to claim that priority in India. So he comes by Paris Convention route, that is conventional application. So he can come within 12 months. So this is basically a conventional application which is originating from outside India, and you can get the patent benefit here by filing the application as a conventional application. Similarly, you can file application in India and you can claim convention application or conventional application in that countries. If you want in that 183, 192 countries, presently 192 countries are member of this Paris Convention. So you can file a application in that countries, right? So this is the application which is based on conventional application. Now, then PCT international application. What is PCT international application? Is governed by the Patent Cooperation Treaty and can be validated up to 155 countries. So at present, 155 countries are member of PCT. So you can just see file application in India, and you can claim priority in all the 158 55 countries which are the members of PCT. So it's a single application, can be filed in order to seek protection in for an invention up to 155 countries throughout the world. So you can just, earlier I told you there was problem, all these problems relating to filing, fees, structure. And in PCT, mind you, the member countries are given benefit. At least 1/3 of the fees is being reduced. Whoever is the member of PCT, there are a lot of benefits, advantages associated with it. The priority date can be opted of filing a PCT application internationally recognized and has an effect in each of the countries. Means you will be given the same treatment as Indian citizen is given in India, in US, or US citizen in India when he is in US. So there is no bar that you are filing other thing. You will get the same treatment in US also as the US citizen gets in US. Then you can file, you can come in national phase by filing the application in 31 months. Now what happens in these 12 months? What happens in these 12 months? So basically the idea is, see, this is Paris Convention and this is PCT route. So once you file a application in a local application, and you can file applications abroad within 12 months. Here, file a local application and you can file a PCT application within 12 months. Here, what happens is PCT conducts a thorough international search, which is provided in 16 months. So, in international search report and opinion is given within 16 months. And if you want to proceed with the application, or if you want to withdraw the application, you have the choice to withdraw here. Now, what is international search report and search opinion? It's the opinion drawn by PCT examiners in WIPO who administers these things. They give a thorough search, they conduct a thorough search and then give a report wherein you get a rough idea whether your invention is patentable, or it is having novelty, or whether it is not having inventive step, or whether it is not having industrial applicability. That can be seen here. And if you want to proceed, then the application gets published in 18 months. Now, if you need further, if you amend something and if you want further assessment or further search report, then you can get a further search report within 12 months. You can again accept for, if you want some months, everything is, and then after 30 months, you can enter the PCT filing international phase, national phase. So this is the basic route where you can file a application. So that is, India has become a signatory of PCT in 1998. So any PCT application is governed by PCT norms. So when an international application is made according to PCT designating India, an applicant can file the national phase application in India within 31 months from the date of international filing date of the priority, whichever is earlier. So now Indian applicant can file PCT international applications in 3 ways. Now how you can file? First, file a patent application in India. After 6 weeks and within 12 months of such filing the PCT, file PCT international application where India is as a receiving office. If India is a receiving office, if international application is filed within 6 months from the filing in India, then according to section 39, permission has to be taken from the patent office. Now what happens? You are filing an application in patent office in India, and after 6 months you are eligible to file an application, and within 12 months you are eligible to file an application for a PCT application. But if somebody accidentally, unknowingly files the application within 6 months, or wants to file an application within 6 months, he has to take permission under section 2039 that he wants to make an application, and that application he can proceed. Then this is the first route where you can originate an application from India. Now file international application at the patent office as the receiving office. So you can directly file a PCT application. You can come by first route by filing an application that may be in the form of provisional application complete, and then you can convert that application into an international application, or directly file a international application, or file the international application at the international bureau according to section. In all above the times, permission has to be taken from the Indian Patent Office. So if you want to directly proceed, you have to necessarily take permission from the Indian Patent Office. Now, that is what is related with PCT. Now, there is another type, that is patent of addition. So when an applicant feels that he has come across an invention which is a improvement or modification of the invention for which he has already applied for or has obtained patent, the applicant can go for patent of addition, and there is no need to pay separate renewal fee for the patent of addition during the term of the main patent, and it expires along with the main patent. Now I told you, you got a patent or you have applied for a patent, and if you want to make some improvement or you want to add something to it so that you feel there is again advancement, then you can file a patent of addition application. By filing an application, here the advantage is that you will get the patent, but you are not required to pay any renewal fees. So once the patent is granted, after third year, you are required to pay renewal fees for a period of 20 years. Accordingly, every year you have to pay the renewal fees. And if the renewal fees is not paid, the patent is lapsed. So there is certain procedure that has to be followed. So that renewal fees you need not pay here, and you can continue invention as with that has been granted to the parent application. So that expires with the main patent. So this दिन first patent has expires, the patent of addition also expires. Then divisional application. I told you application, and once you file a divisional application, then you can claim the invention also in that way, and it is again governed by the same application that is governed under the main application. Okay. Then startup application. Then startup के लिए conditions say for which not there are organizations which is having less than 25 crores, exceed 25 crores. Then they have the advantage of filing. On here you can file a expedited application also. Now this is the another application which I told you that we can be granted it within 1 year. Here now there are certain amendments also been made, that if the applicant is a human inventor, human applicant, she has been given the discount in fees also. So even research organizations, schools, colleges are coming under that category. So again, there is difference in fees which has been reduced. Earlier the fees was higher. Now the fees also has been reduced drastically. So you can file this application. So these 6 to 7 types of applications are clear. समजलं का तुम्हाला? पेटंट कोणीही कुठेही फाईल करू शकतं ज्युरिस्डिक्शन मध्ये. कोणीही मतलब single person jointly with assignee or with the company or with any research organization can file. I told you 6 types of application. You can file ordinary application. Ordinary application file करता येतं. Provisional specification वर 12 महिने मिळतात. 1 वर्षात तुम्ही complete file करू शकता. किंवा direct conventional direct 12 महिन्यात complete file करून application करू शकता. किंवा you have the option of filing conventional application. तुम्ही conventional application file करू शकता, किंवा patent cooperation treaty चं पण application file करू शकता. तर तुम्हाला त्या countries मध्ये protection मिळेल. Then I told you patent of addition. जर तुमचं ऑलरेडी एखादी पेटंट असेल आणि त्याच्यात तुम्ही आणखी काही इम्प्रूव्हमेंट केली तर तुम्हाला त्याच्यावर पेटंट ऑफ ऍडिशन पण मिळतं. आणि 6th क्लॉज आहे तो डिव्हिजनल. जर एका पेटंट ऍप्लिकेशन मध्ये 1 किंवा 2 इन्व्हेन्शन, 2 किंवा 3 इन्व्हेन्शन असतील तर ते तो डिव्हिजनल फाईल करून दुसऱ्या पेटंट मध्ये तो घेऊ शकतो. आणि स्टार्टअपचे ऍप्लिकेशन्स आहे त्याच्यामध्ये तुम्ही एक्सपिडेटेड प्रोसिजर फॉलो करू शकता. याच्यामध्ये 2 क्रायटेरिया आहे. इंडिया इज अ सर्च अथॉरिटी, सो यू कॅन गेट अ सर्च रिपोर्ट और यू कॅन फाईल अ application in directly by expedited route, or if the inventor is a human inventor, she can also file a expedited application. ते हे झाले ऍप्लिकेशन्स. बरोबर आहे, इथपर्यंत क्लिअर आहे? एनी डाउट्स? तर 6 टाईपचे ऍप्लिकेशन्स आपल्याला करता येतात. बेसिकली आपले पहिले 4 फार इम्पॉर्टंट आहे. ऑर्डिनरी बाय प्रोव्हिजनल, ऑर्डिनरी बाय कंप्लीट, और कन्व्हेन्शनल और पीसीटी. तर बेसिकली और नॅशनल फेस, हे 4 ते 5 ऍप्लिकेशन्स फार इम्पॉर्टंट आहे. हिअर यू कॅन गेट द राईट्स. ठीक आहे. आता काय काय लागतं आपल्याला? सो कॅन आय सिट अँड टॉक? Because I need to show some forms. Okay. Now what are the documents that are required to be filed here? काय काय लागतात? जसं तुम्ही घर घेतात, बरोबर आहे? घर घेतात, काय काय कागदपत्र देतात? मीटरकडून सर्टिफिकेट देतात किंवा कोणाकडून मीटर घेतात तर त्याचे काय पेमेंट घेतात किंवा काही प्रोसिजर फॉलो करतात. सॉरी, किंवा आरटीओ ऑफिसला जातात तुम्ही. आरटीओ ऑफिस मध्ये तुम्हाला काहीतरी प्रोसिजर कंप्लीट करायला राईट. आता पेटंट ऑफिस मध्ये भी काही प्रोसिजर आहे, सर्टन डॉक्युमेंट्स विच आर रिक्वायर्ड. आय विल टेल यू द इम्पॉर्टन्स ऑफ दिस डॉक्युमेंट्स. काय काय होतं? तर पहिले डॉक्युमेंट आहे ऍप्लिकेशन फॉर्म ऑन फॉर्म 1 और फॉर्म 18A. व्हेन वी आर टॉकिंग ऑफ फॉर्म 1 मध्ये असाइनमेंट इज व्हेरी इम्पॉर्टंट दॅट वी विल डिस्कस. देन फॉर्म 18A इज फॉर एक्सपिडिटेड filing an application through provisional route. Then form 3 statement and against the foreign filing, right? So whenever you are making, update the patent office by stating that I have got patent in US or I have, so that thing is disclosed. Fact of invention has to be there. Of course, fees you have to discuss. Now, power of attorney. If you are filing the application through patent agent, I told you there are. So happens that you are literate persons, you can understand. Some inventors who don't know how to write or how to explain. That may be the, you hear some person has got a patent, so that thing, so you at that time you can get the help of patent attorney, patent agent. Then he represents your side in the patent office with the controller, right? After provision, form 5 specification, and if somebody needs to the complete specification, right? Able to complete that work within 12 months. What you can do is, you, some research student or some guy invention. So these are the basic requirements that has to be filed along with form. Now form 1. Now form 1 is, if you are filing 30 pages, you have only one fee to be paid. But after 31st page of 500 rupees, then with a complete application, you need to file. That claims exit about 10, then you have to pay fees accordingly. And if you are adding some sequence application where a sequence listing is given, so that has to be submitted in electronic form, and extra fees. Agent shall file the applications electronically. Now when we patent agent tab, online also. Even digital signature with you. So you can file your application digital signature with you. Right? So somebody can do that thing, it is required. And basically when necessary file application through online only and for in fees. So when you make your application online, government is giving. Now understand this is the form. Now here comes the application filing. Now here you have to give applicant's name. Now application through this Shivdare college, right? So and the inventor will be here. The inventor will be here. The inventor will be Gopika madam, right? So she is assigning the right to the college. Then she will write her name itself. But if dispute about ownership arises, because we are facing this kind of problem in many cases also. Like I came at there, the inventor was working with IIT and he has completed his application. And once that application was under the IP policy that was being filed by, signed that policy, but reluctant, he was not signing that document. So here, to avoid that kind of conflict, here you have to necessarily get the signature from the person who has invented. Then you have to write the field of invention. You can see. Then file application in jurisdiction wise. So you have to give the, if you are filing in Bombay jurisdiction and you are filing from, so then if you are claiming any application of priority in the sense if you are filing a divisional application, here the date of parent application has to be mentioned, right? So this is the form which we require to fill, and everything, mind you, all the signatures. Plus, if you are using any biological material, then you have to necessarily take permission for Biodiversity Act if that biological material is from India. So you have that using the biological material which is from India. So here is uses the biological material from India and submitted. So when you are using any biological material, you have to necessarily take permission from the NBA. So that declaration you have to make in this form 1. So this, once this ownership is the main issue here. So here what thing is, that is the basic thing, because applicant inventor is giving power to the applicant. So if in the issue is sorted, because here we have the legal right saying that no, you have assigned your rights to the applicant. And mind you, this is the contract everywhere in any you read your carefully, wherein this clause that all the intellectual property of work will be the property of the organ, with the property of the university. That thing you have to take read the there is a provision made in every company or every organization has that IP policy in place. So whenever you are doing that, the policy that is, so for that purpose, then form 2 may be in the form of provisional specification. Now this is necessarily the form 2 where you have to take, you have to give the details of the title of your filing a provision complete application. Then description that shall start on the next page. Then claim and then abstract. So that we will see in later part. 3. Now, if it so happens that you are filing an international application, so sometimes it so happens that application you are claiming here. So, or if the application is granted in China, so you have to, that gives the written in that country or other country. So whatever foreign filing details are there that you have to disclose, whatever is the state. Then form 3, form 5 is for addition of applicant. So here you can add n number of applicants. If the inventor feels that after filing the provisional specification, he requires the help of some other persons, 2-3 inventors, 2 or 3 of his colleagues. So he can do that and by adding their name also here. Then form 9. So but basically understand, once you file a patent application, it will be published after 18 months. So in order to avoid that queue, you can file a form 9 wherein your application will be published within 1 month from the date of filing or your application. Some extra fees is to be paid here. Form 18 is the form which we need to file for getting your application examined. Okay, then the application will be still pending. But once you file the form 18, your application will be in queue. You will get a request number, and from that request number, your application will proceed for examination. So this is the form which has to be filed within 48 months from the date of filing of the application. If it is not filed within the 48 months, then the application will be treated. Here, another form is form 26. So if you are not proceeding your applications independently and if you want the help of some patent agent, so here you can give them power of to all the correspondence which is being given by patent office on behalf of you. So this is the power you are giving to the dealing with your case. Now, what are the things that are required to be specified in a complete specification? So it should necessarily have the title of invention, then field of invention, background of invention, object of invention, then statement, detailed description of the invention, claims, abstracts, and drawings if any. So all the things, that is section 10 of the Indian Patent Act, which says that the complete specification should be in a detailed manner or in the form. Now, how this complete specifications are drafted, that we can see tomorrow also while doing the search part. So I told you request for the examination has to be filed on form 18. The fees is given on the fee structure that I will show you, but it has to be necessarily filed after within 48 months from the date of filing the application. Or any interested person, and request 18 must be filed at the time of the filing of patent application. Yeah, you can file request for application at the time of filing of application also. When the request for application is not filed within the prescribed period is, I told you, 48 months. The application will be treated as withdrawn and the application cannot be revived. The process. So you got the detailed idea about what things are required. Form 1, Form 2, Form 3, Form 5 if required, then Form 18 and Form 9 if you want to get it published earlier. So these are the forms, and if you are applying through agent, form 26, these are the necessary forms that are required for filing a patent application. Now, what happens with the patent application which you file with the patent office? हे फॉर्म्स लक्षात आले सगळ्यांना? तो लीगल ऍस्पेक्ट आहे, कारण पेटंट इज अ टेक्नो लीगल राईट. Karan, you get a right. So when you get the right, there is legal remedy also. So when the application is filed, तुम्हाला त्याचे rights पण मिळतात. तर आता प्रोसिजर काय होते पेटंट ऑफिस मध्ये? आता तुम्ही इथं पेटंट ऑफिस मध्ये ऍप्लिकेशन फाईल केलं. सपोज यू आर फाइल्ड द ऍप्लिकेशन हियर. Your application will be necessary. months नंतर तुमचं application publish होतं. But I told you can file form 9 and get your application published within 1 month from the date of filing of your invention. So here you can make a request for early publication. Once that request for examination is there, now the role of patent office starts here. Once you get the request for examination, then the applications comes in the examination section. Now examination section are the section where we have a dedicated teams of examiners and controllers. Now what happens if your application is from electronics, or if your application is from mechanical division, or if it is from biotechnology, or either if it is from pharma business, or if it is from any other civil side. So we have a dedicated team of examiners. The application goes to the concerned examiner. Now the examination, the examiner conducts, suppose the application is for biotechnology. It has gone to the biotechnology. Conduct a prior thorough search. Thorough search for what he will conduct? For what he will conduct thorough search? Whether there is whether I told you in the earlier part of the session, what he should necessarily see in that application. There should be an invention, there should be novelty, there should be inventive step, there should be industrial applicability. It should not fall under the exception of section 3 and section 4. So once the examiner, what he does, he conducts a thorough examination and then he cites some document. We have a dedicated databases. Now how search is conducted, that also we will see. But there are certain databases which are paid, so for which we need to pay in dollars also. Like chemical structure search, where we conduct STN search, that is costing us in dollars. So we have a specific team of STN STN search examiner also. So once that search report is forwarded or search examination is converted, the examiner sees that whether there is novelty, whether there is all the report or whatever objection he has, he communicates that objections to the controller. Now what controller does? Controllers checks or verifies the objection and he forwards it to the applicant. Now once the objection set, that is called as first examination report, that is FER. We send a FER. That FER is nothing but the objection or gist of objections communicated. Now the applicant has 6 months time from the date of communication. So once, suppose Gopika madam is the inventor and she is the applicant, we have sent the report to her. She has necessarily she has to reply within a period of 6 months. Now, if it so happens that she is not able to reply within 6 months, so she needs some more time. So she has to make a request by filing an additional petition or making a request stating that she wants some more time to file the reply to your objection. So additionally 3 months time can be given. So here 3 plus 6 plus 3. So total you have applicant has 9 months to revert back. If the applicant doesn't revert back within a period of 9 months, or the application will be treated as abandoned. And if the applicant comes back, again the file goes to the examiner. If he says, no sir, my invention is totally different, the objections, the citations cited by you are totally different, my application doesn't fall, has novelty or has inventive step, and it is not falling under the criteria of any section 3, what you have quoted is wrong. The applicant's reply is being forwarded to examiner who has done the examination. Again, he conducts a search. and then he submits a report to the controller stating that, okay, I agree with the applicant submission. In the case examiner is satisfied with the submissions made by the applicant, he says, now he doesn't have any objection further, you can grant a patent. Then the controller issues a patent to that applicant. But if the report of examiner is adverse, still examiner is adamant, no, this is not correct, the arguments made by the applicant is wrong, or they are not totally correct. So these are still falling under the thing. So at the time when the application comes to the controller issues a hearing notice. Hearing notice just calling the applicant and the examiner also. So necessarily 15 days time is given. As per Act, 10 days time has to be given, but we are giving 15 days time for the applicant to prepare. So once the applicant is prepared, they come to patent office and argue for hearing. So we are working as a civil procedure code. So we are quasi judicial authority. So we call the parties, applicant as well as the examiner, and then the court proceeding starts. Then the applicant argues, sir, this is the thing, my invention is not like that, and my invention is so and so, the examiner has error, or there is examiner has not taken it clearly. Then we hear the examiner also. After hearing both the parties, then you have to submit submissions within 15 days from the date of hearing. And after the hearing is over, after the submissions are there, the control order stating that why he is accepting the application or why he is refusing that. So this is the examination part. So once the examiner applicant controller says that patent can be granted, then the patent is granted. In the meantime, there are two categories of opposition that comes to patent office. One is pre-grant opposition and another is post-grant opposition. Now, under section 25(1), if it so happens that by chance or by mistake, some examiner while conducting research accidentally misses some important document, or accidentally doesn't have the awareness of the patented application, the application for patent, and he misses some important document, then certainly any person can file a pre-grant opposition stating that no sir, no frivolous application has to be granted patent. These are the documents which you have missed. So these are the things. So you have to take into consideration before going in for the grant of the patent application. So here another pre-grant opposition proceeding starts. So here also the controller issues the hearing notice and they appear for the hearing, and then the matter is decided accordingly. Once the submission is made, either controllers accept the pre-grant opposition or the rejects the pre-grant opposition. If he is convinced, and in any case he delivers a reasoned order. A speaking order is being given by pre-grant opposition, and then after post-grant, if it so happens, here any person can file, but in post-grant can be filed by only a person interested. Person interested means, suppose I am working in a pharmaceutical company where paracetamol is my product, and if the invention is relating to paracetamol, the opponent says his interest is being harmed. So he necessarily files an application for post-grant opposition, which can be filed from the 1 year from the date of grant. So this is how the patent application proceedings takes place. So in short, you file an application when you have a conceptualization of an invention. You file an application on Form 1, and then go, or you can file application with provisional, then complete, and then go in for examination. So these are the things. FER is issued, then 48 months time is there within which you have to general procedure. Patent that is from the date of filing the application. So because your priority is from the date of filing of the application, so you will get protection from the date of filing, that is for 20 years. And the date of patent is the date on which you log the protection for a period of 20 years from the date of filing of that application. Certificate to the patentee once 20 years, and you have to file from the third year of the application. So, now what is to be done with the patent? Okay. The another aspects comes of commercialization. How to commercialize that? So there are 2-3 ways of commercialization. Patent to some company who is interested in that patent. There will be many. There is one person. That is, if he has made some face lotion or something, any cold cream or anything which has, and he has got a patent. Immediately, if he is not able to do, then there are sometimes investors also. Hindustan Unilever has a team of particular person. ओके सर, आपको पेटेंट मिल गया, भेज दो हमको, हम इतना पैसा देंगे, या फिर कुछ एग्रीमेंट करो, लाइसेंसिंग करो, हम आपको इतना रिवॉर्ड. These are the things which can be made. You have to necessarily disclose years from the date of getting the. You should not block the monopoly. You can license it, you can assign. I will give you small examples. इन्होंने क्या किया? सिंपल इन्वेंशन है. टासनी वापरतो ना आपण. टासनीचं इन्व्हेन्शन ब्लॉकबस्टर इन्व्हेन्शन. पूर्वीच्या काळी लोक असं ते हे करायचे, तार हे करायचे. एक एंड हे केलं आणि एक नीडल शेप तयार केली. He created wonders. नंतर आपण टाइपराइटर्स, स्टॅपलर. Mind you, they seem to be their line clip, which is then the pin was getting hurt. So to avoid that, also some person has created that line clip. All these things, which see the thing, and now Tasmi, everywhere you are using the line clip, you are everywhere using. Typewriter was there, so there were many inventions like that, which you could have thought of. Now the cap opener, Pepsi tin, or you drink, or you open that Haldiram gulab jamun or rasgulla pack, or many things are there with accompanied. You know how much revenue that person is generating? How much revenue he is generating? 4 crore rupees per day for a period of 20 years. Everywhere. Haldiram, everywhere the packing tin, Pepsi, Cola, everywhere this technology. क्या किया उसने? ढक्कन बनाया, तो ढक्कन का पैसा कमाया. तो ये your brain. We came across that Shark Tank में एक बंदा, the person spraying in farms, you see, he's spraying the spray, trolley type thing, and now he's being hired by you. मालूम है? Old lad with around 8 See the way ये जो चीज है आपको बहुत people who have understood that they have taken advantage. जिनको मालूम है वो यही काम बस पैसा कमा रहे, एक पेटेंट बनाओ, 4 साल में रिसर्च करो, पैसा मिलेगा. Talking itself was the chairman of good inventor. He invented some and he got patent in US also. Many patents लिए थे उसने US. He became Prime Minister of India. He was being called by Rajiv, and then he left. और वो पॉलिसी ड्राफ्ट कर रहा, but accidentally a mishap happened and Rajiv Gandhi was assassinated. Now he was left nowhere. Then what to do? Because he was US जाने के बाद he found कि कुछ आर्टिकल्स पढ़ा में और ये टेक्नोलॉजी he simply wrote a letter, a object, you are using my technology for which and all the things. Earlier only 2 competitors were there, the Nokia और ये बाद में आए Samsung वगैरह. जो पहले competitor थे वो Siemens ही था. Technology they were using. Then they called him, sir, nahi. So they paid him huge. He was made up one of the. So this is how he flourished बाद में. If it is a good invention, it will give you results not at this point, but at certain point of your time. कर सकते हैं, right? So earlier it was not possible, but now people you can think of any problem. Now I didn't brought that. There were Keralites. Or they were sometimes accidentally fallen down, or they get used. I'm just stepping. That videos I had, but I didn't brought here. But there are things, so it's not like that anybody can do this. In that term, this is what we have to say about the procedure. Procedure. पेटेंट किसके लिए चाहिए, इसमें कोई डाउट है क्या? कुछ डाउट्स है? तो अभी कितने लोग पेटेंट फाइल करेंगे? क्योंकि आप तो अभी ग्रेजुएट्स हो गए, पोस्ट ग्रेजुएट स्टूडेंट, कितने दिन बचोगे? 6 महीना के बाद माँ बाप भी बोलेंगे जाओ काम करो. वो एंगल से सोचना है. सब हो गया. Now you have to come out in market. Think in that term कि कुछ ऐसा करे जिसका बेनिफिट आपको रिसर्च में, that will give you benefit through that term. ठीक है? ठीक है? So madam, we will. Any questions? आपको कोई क्वेश्चन है तो पूछो ना. में आगे आपको सब आता है या तो कुछ आता ही नहीं. वगैरह कर देंगे। इंटरनेशनल वेबसाइट्स पे सर्च कैसा करते हैं वो थोड़ा हम दिखाएंगे आपको टुमारो। सो कुछ क्वेश्चंस है? हाँ, टुमारो इफ यू आर हैविंग लैपटॉप्स, अगर कुछ you can work out, we will see actually how the search is being conducted. सांगितलं ना मी तुम्हाला. ते तुम्हाला सांगितलं ना मी, तुम्ही ऑर्डिनरीनी जायचं काही गरज नाही तुम्हाला. पण एकदा लक्ष करता येत नाही. तुम्ही नीट विचार करा प्रोडक्टवर काय करता येईल. हा जो आपण अर्लियर नेसेसरीली, बट असतील तर घेऊन या, घरी पडतीलच ते. जर बघता येतील तुम्हाला काही डाऊट्स असतील तर क्लिअर होतील. आपण उद्या कसं पेटंट सर्च करतो आम्ही दाखवू आणि कसे हे करता येतात आपण ते बघूया. किंवा USPTO युनायटेड स्टेट्सचे कसे बघतो आपण ते, किंवा दुसरे कसे बघतो आपण ते पण सांगूया. हाऊ PCT इज गव्हर्न, PCT असे बी काही रिपोर्ट दाखवतो तुम्हाला. केसेस दाखवेल किंवा कोणाच्या तरी केस दाखवू आम्ही. So we will take your leave, madam. So thank you for patience listening. I hope you got everything after learning. I hope that